can see you, Tim.
You can see?
Yeah. Yeah. Okay.
Okay, very good afternoon to you all. In just a moment, I'm going to be sharing my screen with you and be running this webinar this afternoon on COVID-19 in the planning environment. Just bear with me as I just get the PowerPoint slides that I want to display up on the screen for everybody to see. So sometimes technology is a little bit of a challenge, and even if I've used it a couple of times as I have, it's always something of some degree of interest. But in any event, this should be the correct screen, so bear with me. Okay, so firstly, can I say that we have an amendment to the proposed amendment to the Planning and Development Act, and it is significant and far-reaching. It's entitled COVID-19 Planning Amendment Bill 2020. Now, what I've deciphered from the media releases, the intention of this particular bill is aimed to strategically refocus what urban and regional planning considers to be important. Note that, what urban and regional planning considers to be important, as well as provide a more robust planning environment with a high degree of professionalism and enforcement capability. The intention is to create a more legible and understood system. Now, those last parts there need to be underlined, more legible and understood system, because that at least was what was driving the Green Paper. A number of you would know that Evan Jones was involved in drafting a reform agenda for planning under the leadership at the time of Donna Faragher, and then passed it over to the present Planning Minister. And that Green Paper contains a number of proposals aimed principally and largely at trying to have a system which focuses on strategic planning, a system which is also intended to be better understood. Now, that underpinned a lot of the initiation, or a lot of the proposed amendments which have been subsequently initiated in the amendment bill. Now, the problem that was being identified within the second reading speech was of course, COVID-19. Who hasn't blamed COVID-19 over the last 6 months? But in any event, COVID-19 was certainly seen as a major problem. Now, then additionally, this is what was stated in the second reading speech. There's blame for a lot of what the community sees as bad developments has been laid at the feet of this government by some sections of the community. In fact, many of the developments that people are citing as bad developments are as a result of the planning system. Now, so it is identified that it was the planning system which created the bad developments that we're seeing. Now, I don't know which developments in particular, but one of those that could have been cited, as is often cited to me, is the Coburn development. This is also stated in the second reading speech. The refusal of some local governments to put in clear design guidelines or design review panels to get the best design outcomes out of proposed developments, and councils operating with outdated schemes that do not facilitate orderly development. So when you read the basis of why we need these amendments to the Act, it was seen as COVID-19, bad developments, which was caused by a bad planning system which this government inherited, and also that it was the blame was laid squarely at the feet of local government. Now, as I go along, I don't really readily accept the blame placed at the feet of local government at all, and I want to explain why that's the position. And the bad developments laying at the feet of the previous government of a planning system which this particular government has inherited, well, with the greatest of respect, the Act was what it was for many, many years, and the proposed amendments do really, I think, put us back as opposed to putting us forward in terms of good systems and good development of what is intended to be a more legible and understood system. So the second reading speech continued to explain that the system's complex. They say, look, there was wholesale upzonings in areas. As you know, local government has been placed under particular pressure to get to the 47% infill. And now there's a suggestion that local governments were simply engaging on wholesale upzoning throughout whole areas and the city of Subiaco was identified as something within which this local government, or sorry, this government was involved with the city of Subiaco to try to focus their increase of their densification within their local government district. A lack of focus on the strategic planning by local government, a lack of community engagement, and a lack of defined community benefits in local schemes. And sixthly, the town planning scheme to ensure all local governments have a clear, contemporary and consolidated planning and development vision for their local area. Now, this all comes out of the second reading speech. The second reading speech is some of the most important speech which is given when any amendment to legislation is being proposed, because it's supposed to set the framework of what we can expect within the amendment process that is being embarked on. Now, in addition, this is what the second reading speech said: we have worked with councils like Subiaco to develop schemes that remove potential upzoning for many parts of the suburb and create hubs of density adjacent to the district centres or public transport. This particular, or the Minister also said, we have introduced Design WA and said our reforms are based on three basic premises. Firstly, planning creates great places for people. Secondly, planning is easy to understand and navigate. And thirdly, the planning systems are consistent and efficient. Now, that's at least what the intention was of the amendments. The second reading speech also said that the Planning and Development Act is now a 15-year-old act. Now, bearing in mind that the 1928 Act, Town Planning and Development Act, was really rolled into the Planning and Development Act, and it stood the test of time for more than 70 years. It's a little surprising to suggest that it's an old piece of legislation and it needed updating and repurposing as it described within the second reading speech, and also to elevate strategic planning. Now, if there's ever anything that Evan Jones's paper stood for, is that there was a greater need for strategic planning within this state to look to the future for what is needed, so that developers were able to identify where land would be available for the purposes of their future developments. And increased efficiency and understandability was also something that Evan Jones, particularly in his green paper, focused on. So Evan Jones undertook the review of the planning system, and he came up with a number of initiatives. Now, I want to go to those initiatives in just a moment, because what I'm concerned about is that we seem to have now received what is proposed through this COVID-19, a whole raft of amendments that really make the Minister the king of planning within this state in absolute terms. Now, I have no difficulty with the fact that there may be greater focus on achieving efficiencies, but I am concerned when a system puts so much authority into the hands of one person. For a moment, bear with me, I just want to step back in time, and I want for this purpose to say that our planning system has always been based on plans. But what is starting to emerge over the more recent periods is a planning system based on policy and based on broad strategic objectives, as opposed to statutory plans such as the 1963 Metropolitan Region Scheme. So to the left, you'll see what you know as the Stephenson and Hepburn Plan. Effectively, what it identified was that the land surrounding the rivers, being the Canning River down to the south towards Armidale, out towards Midland being Swan River, and the corridors along the coastal strips down to Rockingham and north to Joondalup, were those areas which should be considered for the purpose of future development. And then to the left, the Metropolitan Region Scheme was developed in 1963, and it put colours on paper. It identified where the major strategic routes were going to be, how the road networks were going to interlink with the urban development, where your industrial development was going to be, where your major regional parks were going to be, and what areas were to be set aside for reservation purposes. Now, that plan of 1963 stood the test of time. There were a few iterations, of course. The 1974 Corridor Plan. There was also another plan in 1984 until 1990 Metro Plan. And subsequently, and I do skip over the strategic planning, but moving towards what was known as Directions 2031, which was intended to bring together what land would be capable of development and where the strategic development would occur. Then you've got, of course, the Perth and Peel 3.5 million, identifying the major network corridors. Now, that was not put and released by the minister, the previous Minister for Planning, but this minister released it on the 23rd of March 2018. And the Minister, Saffioti, said, we want to create dynamic communities where people live close to where they work, where they are supported by world-class public transport networks, and where they have parks and shops and all other amenities that contribute to the West Australian lifestyle. And these whole of government plans define the urban form through a coordinated approach to land use and infrastructure planning. And she also said, and these are things that she was permitted everybody to quote her on, she said, they lay the groundwork for high livability, vibrant new communities, particularly through greater infill development around key transport links. And then this paragraph, or this statement, including the new Metromet stations. Now, there is a problem with that plan. It was, of course, developed before Metronet was put out. And so accordingly, if you look closely, as I do with this next slide, at where the major railway networks are going to be located, you will see that it has done very little, if anything at all, in terms of where the major intensification and high density infill development would be surrounding those train stations as being the key hub or the key purpose to which that plan was put. So the suggestion that directions, sorry, not directions 2031, Perth Peel 3.5 million was for the purposes of facilitating and including the new Metromet stations is lost on the spatial plan, because it doesn't appear as if that was in fact the purpose for which this particular parcel of land was put, or sorry, this particular plan, the purpose to which this plan was put. If you go to Metronet and its website nowadays, and I will go through the different agencies that are involved in Metronet planning, but it says Metronet is the long-term blueprint for Perth's future planning needs. Now, let that sink in for a moment, because I have not seen anywhere where it has been suggested that the current spatial planning framework is a blueprint for Perth's future planning needs. And you'll see also on Metronet's website, with approximately 72 kilometres of new railway, new passenger rail, and up to 18 new stations, Metronet is a catalyst to turn 5,000 hectares of land around new stations to desirable places for investment in housing, jobs, and service for growing communities. As one of the largest single investments in public transport that the city has seen, Metronet will help positively change how people live and travel. I'm being joined by my colleague here, Bronwyn, who's also an associate or a director within our office. So, hi, Bron. The point is that there is a disconnect between the spatial framework contained in Perth Peel 3.5 million and Metronet as a future long-term blueprint, for Perth Peel planning needs. Now, the real problem was identified in the Green Paper, and it said that in Western Australia, a variety of structured planning approaches are undertaken for key locations of activity centres, urban corridors and station precincts, and they range from developer-led to local government-led to state-led by Landcorp, the MRA, the WAPC, and more recently Metronet. Now, this is the paper that Evan Jones published, and it's a paper in which he identifies that in fact there are so many different government agencies and different planning agencies involved in the delivery of this blueprint. But the reality of it is that there is no real blueprint. And Ron just suggested that I move a little bit to the side. So the problem is that there is no spatial plan at all for the implementation. And so the types of issues that were identified almost as an adjunct to Evan Jones's report identify some of the issues that Metronet, as a railway development planning blueprint, has not found its way in the planning frameworks because it wasn't considered for a very long period of time. So there's a disconnect. There's a disconnect between the spatial framework of Perth Peel 3.5 million and MetroNet and what it is intending to achieve. And as you can see, this was identified when Evan Jones finished his report, and it was included in his report as being a mishmash of many different government agencies who are leading up. What are we going to do around where these train stations have been identified? It's not identified within the blueprint, being Perth Peel 3.5, but now we have to make sure that these areas of the train stations are going to meet what the government objectives intentions are, even where there might not be infrastructure, even where the land has not been planned for a very extended period of time surrounding those train stations. Now, we all know one thing. Strategic planning takes a very long time to get underway, and strategic planning is a very difficult thing to put into place, or strategic planning is difficult to achieve because of so many different agencies having so much input that when you look at maps, you're trying to identify where land is able to be developed. And you're looking also at the infrastructure, sewerage, water and other infrastructure, and it's a significant change. Now, the real problem that I say is that there's so many different agencies now involved in a new blueprint for planning, the MRA, Land Corp, Land Authority, WAPC, local governments, PTA, MetroNet, and the DAPs, that trying to deliver on the 47% infill density is left without a clear, coherent blueprint, which was the intention of MetroNet. MetroNet is outside the current planning framework, and the current focus of strategies such as the Network Cities Directions 2031 and Perth Peel 3.5 million are all strategies which have not properly considered the implications of MetroNet. Now, the Minister's powers, so if you don't have a good blueprint, if you don't have a document which identifies how you're going to deliver on MetroNet, then you need to ensure that the Minister has extensive powers. Now, the Minister in her second reading speech did say, I also want to make very clear that the proposed reforms are not about giving the Minister for Planning all-encompassing powers. These reforms cannot compare with other states where planning ministers can call in and determine any major developmental project. That might have been the case, but my concern, and it is for us as planners, as lawyers and planners and people involved in the planning system, to really raise issues where we see them, because I see everybody getting on board at the moment and saying this is the greatest thing ever. But there's a few real concerns that will come to the fore through this particular paper and this particular presentation this afternoon. Firstly, the extent of the ministerial powers. Secondly, the only people who are really going to get benefit out of it is the big end of town, 100 lots or 20,000 square metres of land being developed and $30 million in value. So that's the big end of town, the very broad ministerial powers, and unfortunately my view on the crushing weight of some of those powers on the very good work that local government has done. So now I just want to talk about the fact that there is a lack of blueprint. There's a lack of planning direction within the planning framework that is in existence at the present time. And the problem is that the Minister has, through the process, implemented a system whereby, unfortunately, she has been, in effect, given significant powers, contrary to what she said in her second reading speech. So the ministerial powers include the power to direct any decision maker to perform its functions in a certain way, any decision maker. And as I come through the legislation, you will also see it doesn't matter whether that is beyond power. It is in effect through these COVID-19 amendments, which are in place for 18 months, but some of them are longer. But there is, the Minister can direct and people need to make it happen regardless of whether they have the statutory power to do so. I'm going to come to that in a little moment, because anybody acting beyond power, you will know that if you don't have the power given to you by legislation, you can't do anything. And if you are acting beyond power, it's vulnerable to attack, even if another piece of legislation says that it is lawful, in my view. We'll come to that. The Minister can recommend to the Premier to refer a proposal deemed to be of state significance to the Commission. So the Minister can say to the Premier, Premier, I want you to say that this is one of these proposals that ought to be referred to the Commission for determination. And 3, empower the Minister to withdraw a regional planning scheme amendment partway through the process. There is some red tape clarifications as well, that the Minister must approve a proposed local scheme or scheme amendment for advertising, with the intent being to avoid advertising of schemes that the Minister is never going to approve. And the Minister retains power under section 17 to direct the Commission. Now, I'll come to that in just a moment. I just want to focus a little more broadly on these powers that the proposed amendments are going to give the Minister. The Minister can require the Commission to make a state or modify a state planning policy or amendment. The Minister can require the Commission to make modifications to what is called planning codes. The planning codes are like the R codes, so the R codes are going to be replaced entirely. Look at section 32 of the proposed amendments. So the Minister can say to the Commission, I want you to change one of these planning codes, and the Minister may order the local government within such time as is specified in the order or as the case requires, to prepare a scheme or an amendment to the scheme, to adopt or submit to the Minister an amendment to the scheme, or to take any step or give effect to the decision referred to above to prepare a scheme. So, in very broad parameters, the Minister can say, I want you to change your planning policy, your state planning policy in this way. In addition, I want you to change your proposed planning codes, R codes, in this way. That's to the Commission. And the Minister can also say to a local government, I want you to amend your town planning schemes. Now, bear with me for just a moment, because this I need to develop a little bit further. So you've got the Minister who is able to give all of these directions, and these directions need to be adhered to, really changing the face of planning. And the power rests with the Minister in respect of each one of these. Now, the Minister, under section 77, the local government is, of course, as we always know, to have regard when it's developing its own schemes to state planning policies. That continues to be the case. And to planning now, in addition, they must have regard to planning codes. But importantly, these new planning codes, which are developed by the Commission, are going to be incorporated by reference as if they were part of the scheme. So you're going to have codes which are going to automatically be implemented as part of the scheme. Now, Evan Jones made a very interesting point. He said that there are some aspirational policies and there are other policies which have legislative type effect. Now, R codes, we all know for a very long time, were one of the latter type of policies. That was that they were intended to have some form of legislative effect. Now, regulations are now going to be implemented, and those are going to be planning codes, and they are going to be implemented as part of the scheme of any local government. And the Minister has the power to make any amendments as she would see fit, or direct that any amendments be made by the Commission to any of these codes. So section 276(2), the Commission must consult with the Minister and give the Minister a reasonable opportunity to be heard. I'll come to the importance of this in just a moment, but just for the present, the importance for that is just to show that the Minister has significant power and can direct, consult with the Minister and give the Minister the reasonable opportunity to be heard. And the Commission, in making a decision on development within the means of those matters which are referred, is to have due regard to any submissions made by the Minister. Now, while we're moving along, you're welcome to click on your screen and you'll see that there are ways within which you can have input or you can raise questions. Don't hesitate to do that as we're moving through this afternoon. We would be able to see once you want to raise your hand or alternatively speak to us or have a chat. So don't hesitate to do that as we're moving through, and Bron will keep an eye on that in particular. Now, the other very concerning matter is that no one has the right of appeal or any approval of the Commission. If the Commission grants an approval, there is no rights of appeal apart from to the applicant. The applicant does have a right of appeal, but it's not like the local government can go and appeal a decision that has been made by the Commission. So the decision maker may be directed, and even if they do not have the statutory power under section 280 subsection 6, the decision maker is required to comply with whatever the direction is that is given to them. So very, very broad powers to the Minister that is proposed under COVID-19. Now, just to develop what I am concerned about, I'm concerned that we have a planning framework which is intended to rely on Perth's blueprint when we don't have a blueprint for MetroNet. There is no spatial framework, and now what we are seeing is that the Minister has powers to direct how planning schemes are to be amended in accordance with state planning policies and codes, planning codes, and the Minister is able to direct an amendment to a scheme or a new scheme to be adopted or take any such steps. So there is broad-based powers without rights of appeal by a local government, and the local government or any decision maker is able to be directed to do certain things with which they must comply, even if they don't believe that they have the statutory power to do it. Quite extraordinary. It is a matter that I think is of some degree of concern. Now, going back to the concern that we don't have a legible and a clear planning framework. Notice that I've made the case at the present time that the Minister has very broad powers that are intended under the legislative amendments. The State Planning Framework Policy number 1, or SPP 1, set the framework within this state for the way within which planning decisions were to be made. You had the overarching state planning strategy principles. You had the state planning framework, which included all of those principles: community, economy, environment, infrastructure, regional development and governance. Now, these very important principles found their articulation in various other planning strategies and planning documents, and they were intended to have application to local planning strategies. As you know, local planning strategies are required to comply with state planning policy, and the framework was intended to be that you have an overarching system, and the process was whereby local governments would then comply with ensuring that there would be a process of the local governments implementing what the state planning framework through the different processes were. Now, there was a question here. Bron, do you want to read it?
Sorry, I may have misunderstood. Did you say that there will be a need for the Minister to approve advertising of a local planning scheme amendment to avoid advertising of amendments that will be refused?
I'm not quite sure on that question. Did I say that there'll be a need for the Minister to approve advertising? What I've said is that the Minister's, the Minister's able to direct amendments to schemes. Interestingly, when we come to the powers of the Commission doesn't have to apply schemes at all. It can only have due regard to those schemes, or it only has to have due regard. And I'll speak a little bit about what due regard means. But at the present, I am not certain whether we need a planning framework which in effect gives all the power to the Minister. That's my concern. I'm concerned that we don't even need that in the times of COVID-19. Yes, greater efficiencies by all means. A specialised JDAP or a DAP, sorry, by all means. A specialised DAP that could also see that the requirements that are imposed by way of conditions are not held up by the various government agencies, by all means. But I am not certain whether resting all of the powers for state planning need to rest with the Minister, because that's what the proposal is. I'm not certain that the case has been made out based on COVID-19. I had a little cough, and don't worry about that, I'm not affected. But I'm not certain that we need to depart so significantly from this state planning framework that we need to provide the Minister with all of the relevant powers, as opposed to providing and ensuring that we have a state planning framework that is overseen by the Minister. Because let's face it, no politician is really a planner. And we still need to ensure that we've got good planning. If Directions 2031 took about 15 years to develop, from about 2003-4, when it was probably first mooted or thereabout, and took a significant amount of time to get through the process. And then we had Perth Peel 3.5 million, which built largely on Directions 2031 as a spatial framework. Then I say that that takes into account the best minds within planning. And I think it also takes into account those concerns and matters which are relevant to planners. What we find is a system now being celebrated by planners, whereas I think that there's no reason for celebration, because my view is that the proposed COVID-19 amendments, which although have a sunset within 18 months, give the minister significant powers, as I've already outlined, which are not required because of COVID-19. And let me say this and predict this. Once this occurs, reversing this is going to be extraordinarily difficult. It is intended for the big end of town, have no doubt. However, a state planning framework and a planning framework which builds on strategic frameworks and state planning policies, which are required to be implemented through local planning strategies and town planning schemes, and the 2015 regulations, which amended town planning schemes through deemed provisions, are more than sufficient to ensure that there is a consistent framework. Now, Evan Jones, within his green paper, made the point that we have a problem because some of the state planning framework is old and some of the state planning policies have not been fixed up or changed to more modern planning principles. Now, there's also the criticism made that local governments have not amended their town planning scheme for many years. The Planning and Development Act, as it presently stands, has given the power to the minister to be able to direct that there are amendments which are able to be made or be required to be made to town planning schemes. So new schemes are required to be implemented. So I am concerned that we are running headlong to granting all of the powers to the minister, and nobody has been blowing the whistle on this particular concern. Rather, what we end up with is a possibility of a framework where the minister can direct how local governments change their policies, direct the state planning policies, direct the planning codes which are proposed to be implemented, and also under section 17, the minister is able to direct the commission how it is to decide a matter. Now that's a worry. If you've got the power as the minister, to direct the commission how it is to decide a matter, and then it's required to take that into account, and you've given the minister all of the relevant powers under the Act, you can see that we have a set of circumstances where there is significant powers being granted. Now there's another great question. Bron, do you want to read that?
Do you know whether other states which have had much higher COVID-19 cases than WA have also amended their planning legislation to give significant powers to the minister?
Okay, yes, New South Wales, in fact, has a long-standing, not a direct amendment, but New South Wales has had a long-standing process whereby proposals of state significance, which are particularly identified, not a loose framework, but that the minister is then able to call them in effect and have oversight over those particular powers or those particular projects. But the state planning framework is not thrown out in effect, and that's what I'm concerned about. Now, I'll be criticised for suggesting that the state planning framework is being thrown out because ultimately, when the Commission comes to make decisions, the Commission is still required to have regard to those matters of good planning nature, which within the state planning framework. But there is, I say, an opportunity for the minister to direct state planning policies to be changed, to direct state planning codes to be changed, or the planning codes to be changed, as well as the town planning schemes. And then once all those are amended, then to direct the Commission, how the Commission is to decide a matter, and the Commission is only required to have due regard to town planning schemes, policies, codes, and other instruments of the planning framework. So I'm concerned that we are going down a path where we actually give a significant amount of power away. Local government is significantly diminished in what it's able to do and its powers. We've already got DAPs, which take away significantly from local government at the present time. and we are now moving to a state system where the minister is almost given all powers. So perhaps I can go to the next slide. It is concerning that even if there is no power, the decision maker under section 2816 of the new Act, the decision maker must comply even if that involves doing something or omitting to do something that apart from, and this is the wording of the amendment, this is the wording of the legislation, it's not mine, that apart from this subsection, the decision maker could not do or could not admit to do under any legal instrument. Now the point is that the decision maker has to do it even if they didn't have the powers to do it under statute. That's concerning because the only way within which anybody is able to act is in accordance with the statute. It means, in effect, if you are asked to do something which you have no lawful basis for, or perhaps put a little highly, if you are asked to do something which is unlawful, you're required to do it. Section 2816B, without limiting the paragraphs A, despite any time limit that would, apart from this subsection, apply under any legal instrument in relation to anything which the direction relates. So you have to do it regardless of the time limits that might be provided. And that's the proposed amendments, and that's the extent of the proposed powers. Now, it also says that the governor can amend or cancel any approval by the commission. Now, the governor is in effect, of course, the cabinet. So the cabinet directs the governor, in effect the premier. So where an approval is granted by the commission, so let's say the commission considers an application and the approval is then granted by the commission, the governor is required, or the governor or the premier is able to amend a condition. So not only is there a power by the minister to direct how the commission is to decide a matter, but if a matter is decided and the cabinet of the day isn't happy with it, the cabinet is then able to amend or remove any conditions or impose new conditions or amend any part of the aspect of the development in any other way or amend the approval in any other way. Now, what I'm saying is that this is very, very broad powers to the minister. Another question, Bron.
David has said, so who then wears the liability for acting ultra vires? Potentially places a lot of liability on local governments.
Yep, absolutely. Oh, look, I'm concerned about that. I'm concerned, as you will see a little bit later on, that there's a conflict between the Environmental Protection Act and what it states and what the intentions are. So there's unhappy conflicts. I say again, it is perfectly legitimate to have a development assessment panel for major developments within this state and for that development assessment panel to follow through to ensure that any development of a state or regional significance is not held up. But I am concerned that this very broad-based powers extends to directing local government to do certain things. And remember, local government has been kicked, and I've said that it is not the local governments who are the multiplicity of state agencies such as the MRA, the Land Corp, Land Authority, Metronet, and all the different agencies who have pseudo or certain planning powers in addition to the WAPC. It is not local government who is to be suggested that they are at fault or to be blamed for what is described as poor development, such as Coburn Central. And I only pick on that one because it's got high-rise development. It's a parcel of land which is adjacent to the train station, but it's been segmented and really is not, I think, from most analysis, a particularly good form of development adjacent to railways. In any event, this is the powers under section 17 that the minister presently has. The minister may give written direction to the commission with respect to the exercise of the performance of its functions, either generally or in relation to a particular matter, and the commission is to give effect to any such direction. So the minister is capable of telling the commission how to do certain things, and the commission is required to. Now that's in existence today, but if you give the commission the powers that is proposed by this COVID-19, and then you have the power to direct the commission, and you have the powers to amend any conditions even if they were imposed, you are really setting up a process which is not the subject of a lot of review. We do not have the checks and balances in this proposal. there is nothing by which anybody is able to say, in effect, you're acting unlawfully, because the Act is intending to make all of the actions, even if they were ultra vires, lawful by an amendment to the legislation. Now, I don't know that that's particularly lawful or that's particularly proper, but that is the proposal. So we end up with a system where the Minister is able to give directions to the Commission. The Minister is able to make amendments to state planning framework, to direct that town planning schemes is to be amended, that planning codes are to be amended and to be implemented. And you've got a system now, or proposed, that does not have what is necessary within any planning framework by way of the checks and balances. There is no right, and you'll see a little later on, there is no right from a local government's perspective to review or seek a review of a decision by way of an appeal to the State Administrative Tribunal or any other agency. Whereas in other states we see that there's still rights of review at the very least. So the 5 key framework amendments, which was in the Green Paper, which these amendments that are proposed build on this, but they do it in a little bit of an unhappy way. But the Green Paper at least said, look, these are the 5 things that we need to make sure that we change our system with. Nothing in these proposed amendments and the Green Paper's reforms say that we need to give greater power to the Minister. Now, I realise that a lot of them are intended or are said to have an 18-month time frame within which they will then no longer apply. But nevertheless, to say that there has been significant consultation and that the end of the process is to throw aside all good planning direction and just simply say the Minister's able to make all decisions, and I realise that's the extreme, but that is the potential of this particular proposed amendment, is, in my view, not really giving weight to what has been said within the Green Paper, which is to say, let's focus on a more strategic type planning approach. Let's make sure that the system is legible and understood and transparent as well as efficient and delivering on smart growth. Now, I'll leave you to read these proposed amendments for that come out of the Green Paper. But for example, strategically led system is to ensure that there is a process contained within the Planning and Development Act that focuses on strategic planning. And in that respect, the focus for local governments is on their planning strategies. Now, all local governments are required to have a planning strategy that looks 15 years into the future. To some extent, it could be a relevant criticism that some local governments don't keep that updated on a regular basis. And it could be said that some local governments struggle to even implement a local planning strategy. But a local planning strategies, equally, I've seen them being held up by state government agencies. So the suggestion simply that a local planning strategy has to be implemented, but once, and for that reason, the system is broken and not strategically led because we don't have local planning strategies, I don't think has a proper or a significant basis that has at least been properly articulated, because the local planning strategies themselves need to adhere to state planning policies. And local planning strategies have been held up. Now, I'm accepting for a moment that there are some local governments that do not regularly update their local planning strategy, and this local planning strategy, having a 15-year horizon, has not always articulated very well the strategic framework for local government, the planning environment from the state-based initiatives. But nevertheless, this is not the linchpin to providing a more strategically led system, that is local government strategy, local planning strategies. A legible system, and these are quotes taken straight out of the Green Paper. The state planning policies have developed over many years, and many policies are not in a form capable of direct implementation. Now, nowhere have I read within the state, within the second reading speech, that is that the state planning policies developed over many years, and many policies are not in a form capable of direct implementation. It is recognised that one of the limbs of the amendment process is to focus on state planning policies. But nevertheless, I am a little critical because that really is what drives all of the rest of the planning framework. At the pinnacle of our planning framework is the state planning policies. And it's important and imperative that the state planning policies drive the strategic direction in this state for planning, not the local planning strategies. So for state planning policies to lead the WA planning system, it's proposed that they be consolidated together in one single, concise state planning framework. Now, that's okay. I don't mind whether you call it a state planning policy or a state planning framework. What is important is that the system is at least understood and clear. And for that reason, Evans-Jones has proposed separating out the state planning framework into those which have legislative functions, such as the R codes, and those which have strategic functions. And a third fundamental step in organising the WA planning system is for having a comprehensive local planning scheme. That stands to reason, and there is an excessive level of inconsistencies across schemes. And Evans-Jones did an assessment and suggested that some local governments have up to 20 different zones within their town planning schemes, making it very difficult to understand the system. But nothing of this either suggests that the Minister, therefore, needs to be able to give directions to the extent that is now being proposed by the amendments. A transparent system, following New South Wales and South Australia's proposed that a community engagement charter will need to be developed. Now, interestingly, the community engagement, which is set out in section 45 of the Planning and Development Act, is now proposed to be included within regulations. What we have not seen is what this community engagement is going to look like. Yet it is a linchpin of this new planning system that there be greater community engagement. But how it's going to appear, wait for it, that'll be in regulations. We don't know as yet, but it is said, don't you worry, we're going to take it out of this Act and we're going to include it in regulations. That means that community engagement requirements are going to be able to be amended much more quickly, much more easily, and much more flexibly. That's a benefit, but it's also a detriment because it's not going to be the subject of full scrutiny of the Parliament, because regulations can be passed and have to be laid before both houses of Parliament for, I think, 28 days or 56 days. Should know it's under the Interpretation Act. I think it's about 28 days. But anyway, not for a very long time. It means that if you are going to change your planning framework through regulation amendment, you can do that very, very easily. Standards, the local planning regulations, are going to take a greater weight. So we're going to move to greater policy and greater local planning strategies and requirements that the regulations or more regulations. So an efficient system is proposed or was proposed under the green paper that was developed by Evan to seek, and this will interest most people, to look for pre-lodgement advice. So before you lodge your proposal, that there will be pre-lodgement advice. Now, this is going to be possible for these significant development proposals which can be sent off to the Commission, handled by the Department, and the Department can give pre-lodgement advice in respect of any proposal. So that's going to be included within regulations and how that's going to be taken effect, because it's not included at the present time within the Act itself, but the method or the intention is that the Department is able to be sought, or you can seek advice from the Department. And then within 10 business days, if additional information is required, they need to provide that information. So it's 28 days, thanks Bron, under the Interpretation Act. So you lay a regulation before both houses of Parliament, and that has to stay there for 28 days. So these, and then the final systems was to provide for smart growth for forward planning of the state infrastructure. So local governments are aware of state infrastructure. Now, I don't see local governments as being blamed here for not seeing the forwards planning of the state infrastructure. I don't see, the WAPC will assist with infrastructure coordination and delivery of priority precincts. And then number 3, local planning strategies to include a section on infrastructure and priority links. That'll feed back into what is needed for the future. And number 4, the Metropolitan Region Scheme is to be updated to include the urban corridor as a category of road based on Perth Peel 3.5 million. Interestingly, there wasn't a specific reference under smart growth for the purposes of MetroNet. Now we do have another question. What counts as a significant process or a proposal which goes to the state, straight to the WAPC? Now, because I'm going to answer that question by reference to one of my slides, because I'm coming to that now. What I just wanted to set out was that the green paper proposed amendments, which we do not presently see within the proposed amendments to the Act. I've said that we've got a system which is at the present time in place, which is provided a blueprint for planning, Perth Peel 3.5 million. And what I'm saying is that we don't have the blueprint, and the COVID-19 seems to be a more convenient way to set the principles, but also to give the Minister for Planning very significant powers that once handed over, I see limited chance of retrieving all of those powers, because at least the big end of town, which gets the benefit, and I'll talk about what the significant proposals are in just a moment, are going to get significant benefit out of this proposed amendment to get the state back on its feet. That was the intention. I think it's a process which actually ensures that the state planning strategic direction and framework is not being adhered to. So key reforms, they're intended to be in three key areas really. Planning and Development Act, those are the amendments that we're discussing at the moment. Then the regulations, both to the Planning and Development Local Scheme regulations as well as the DAPs, and the State Planning Policy Framework, which we'll talk about in just a moment. Those are the key reform areas, at least referred to in the second reading speech. So the Planning and Development Act focuses on strategic planning. That's the intention, and a new process for significant projects to reconcile the conflict between the approval processes which are in place at the present time, they say, and simplify regional scheme and state planning processes. And now this is the answer to the question, Katrina. So significant developments and ministerial referrals. This is the key. If it's going to be a significant development, it must be at least 30 million and 100 or more dwellings. So that's the first thing. So pretty big development, subdivision in other words. And the bill says to a development to which the R codes apply, or a minimum of 20,000 nettable let area, which is not intended to include a warehouse. So if you are proposing a form of development and you've got 20,000 square metres of net developable area, then in those circumstances, it would, and it's at least $30 million, it would fall within the category of a significant process that goes to, or is capable of going to the WAPC. Now, Katrina, you don't make the application to the local government, which is then referred to the WAPC, you go straight to the Department of Planning and Housing. Department of Planning, Land and Heritage, my apologies. They change these acronyms, and Katrina, you've been around for long enough to probably get as confused sometimes as I am with the names of them. But anyway, the point of it is that it is the case that it needs to be a significant development. It's the big end of town that is going to be referred to the Commission, and it is the department which is going to receive those applications. Now, in addition, the Minister could consider that something is of state or regional importance. There is no review process to what the Minister might consider to be of state or regional importance, or the Minister recommends to the Premier to direct a referral to the Commission for decision. Now, bear in mind the only other two matters. It does not include the MRA areas, so those areas just outside of Armidale and Midland and some other areas around Perth. And it does not include the Hope Valley Wattle Up areas. So let's have a little look at these COVID-19 amendments. The Premier is also able to refer a proposal, can notify the Minister can consider it to be of state or regional importance, and then can refer the matter under section 274 to the Commission, or if as stated already, and I've repeated in this slide, sorry for that, 4 and 5, where the Minister can refer it as well as the Premier can advise the Minister, and no referral possible. This is an important point. If the matter has already been referred and decided by a local government or another government agency, and the matter is before the SAT, doesn't mean that you can pull it out of the SAT and then say, well, now I want to have it determined by the Commission because it's a matter of significance. So if it's already been determined, you're done. So that's something of importance. Now, section 274, the Commission must determine the application as soon as reasonably practicable. It does not say what that means. The Commission can impose a condition requiring further details specified in the approval before the development is commenced. Now notice that. This is a fairly interesting suggestion. So you can impose conditions, and the condition can be that you have to satisfy us of certain matters before you commence your development, but you can have your approval already in place, subject to those additional details being provided at a later point. And then the important thing is, provided that those further details do not change the approved development in its entirety. You can't go from complete change of the development, but it might be subject to, for example, Aboriginal heritage assessment, or it might be subject to a clearing approval, those types of things. Okay, section 275 is where it's at. Just in summary, this enables the Commission to take into account non-planning matters in the public interest. Very broad-based. Precisely what those matters are is unclear, but the Commission is able to take those matters into account. It can engage with the EPA on significant development proposals to ensure efficiency and ensure that matters are referred quickly. There's no authority to make a decision inconsistent with the decision of the Commission, so the local government can't refuse it. And a legal instrument does not apply, and the Commission is not restricted by a legal instrument. Now, I'm coming to what a legal instrument is in just a moment.
We've got a good question from Katrina coming in here.
Okay.
If you have a TPS amendment for 100 houses at $40 million and then subdivide it, say 20 lots at a time, is the subdivision still significant, or does it need to go to local government? This seems problematic.
Yep. Absolutely, Katrina, and there's lots of those little things. What is clear is that you can make a submission to the Minister and say this is a proposal which is of state or regional significance or falls within the criteria if you are refused from acceptance. But it will be the aggregation, even if it's 20 lots at a time. There is, however, the Commission can say that, look, this is not a proposal that's going to be implemented at any time soon, and for that reason we're not going to consider it. So bear that in mind. So if it's sort of a long-term proposal that is not going to be implemented any time soon, the Commission can refuse it, for example, because, I don't know, it might not have major roads, or it might not have infrastructure such as sewerage and the like. So notice here what the Commission does. The Commission is to have due regard to submissions that it receives, the planning framework, the local government and the Minister for Planning, and I'll come to that and I'll explain all of these things in a little more detail in just a moment, and any other matter that affects the public interest, and it includes the effects of COVID-19, and it's not bound by the law, including the town planning schemes. Now, this is just some of the overarching provisions. We're going to look at these provisions of the Act in just a moment. So in other words, the Commission is not bound by a town planning scheme, it's not bound by a region scheme, it's not bound by what other environmental strategies and policies might require. It is, however, to have due regard to those matters of the planning framework, including the state planning policies, and it has due regard to the government and to local government and what the Minister says. And so if the Minister says something, its word is something to which it must have, that is the local government, the Commission is to have due regard, and there is these broad public interest tests. Now, I have to say that I think we're moving into a framework which is much broader than anything you could ever have imagined. Bear in mind that I was critical previously of the extent of the powers which enables the Minister to give certain directions and work outside of the planning framework and processes and decide what is necessary for amendment of the state planning policies and codes. I think that we are now moving into a position where the Commission, what the Minister says, you have to just listen to the Minister and have due regard. What is bound?
What is it bound by?
Yeah, just what the Minister says, and you got it. You absolutely got it, and that's my concern. And so what I'm seeing is a whole lot of planners who are saying this is fantastic. You know, we're really going to see a removal of the processes, and it's going. All the roadblocks are going to be removed. But equally, my concern is that if the Minister decides something, you're done. So somebody might say, with a tongue-in-cheek, and I'm not suggesting this at all, that it'd be a good idea to have a corporate box at the Fremantle Oval. But anyway, the point of it is, and the point that I think has to be made, that I'm not suggesting anybody is going to do anything improper, but the process that is proposed gives a significant amount of authority to the Minister without any oversight. And that's where lawyers and people involved in the system have to ring the bell and have to say, look, with a system that we're proposing at the present, even though COVID-19 does mean that we have to increase efficiencies and get the processes acting more quickly.
So it needs to be checks and balances.
Needs to be checks and balances. And you could, for example, have a DAP that says, okay, we're going to take into account a local government's input, and that could include the planning input, the building input from the building department and the people, if it's a food industry, the environmental health officers. And that's what that particular government agency, and it could say, we require you to give us the input within 21 days. And that could then form part of the framework. And then it could also include the requirement for clearing approval within, I don't know, 21 days. But this process doesn't look at where the roadblocks are, but rather gives the powers to the minister in absolute terms. And it's for that reason that you've got to be concerned. I am not suggesting that anybody would act improperly. Please understand that. That's not my suggestion. But what I am saying is that we need to have a system that has the appropriate checks and balances so that we all can be confident of the framework, number one. And number two, that you know what it is that you need to address, not only in your applications, but also addressed by way of an application for a review. Because if you're refused, it could be on the whim of the fact that it is contrary to the matters that the ministers told the local government, told the Commission to have due regard to. So just some concerns, and I think it's important for us to ensure that when we have these processes which are being proposed, that the people that do have some degree of understanding at least ring the bell and say, hold on, we need some forms of checks and balances. Section 275, this is the exact provision to take from the Act. I just want to talk about Section 275(3). So without limiting subsection Section 271, for the purposes of the Commission's consideration and determination of a development application, the legal instrument does not apply, and the Commission is not otherwise bound or restricted by the legal instrument. Now let's have a look at what the legal instrument is. It's defined here as any enactments included in the Contaminated Sites Act, Environmental Protection Act, the Heritage Act, Swan Valley Management Act, Swan Valley Act, the Waterways Act, it used to be called that, Swan and Canning Rivers Management Act, Swan Valley Planning Act 1995. And then notice this, any other enactment or any enactment other than this Act or an enactment covered by paragraph B. A planning scheme or an interim development order or any other scheme, code, policy, plan, local law, bylaw, rule, condition, notice or otherwise, or other instrument under any other enactment. Now, that's broad. In other words, you don't have to listen to any other legislation, town planning schemes, region schemes, or any other piece of legislation. What you decide as the minister, what you decide as the Commission goes. And bear in mind, we're blowing the whistle and saying we need to have review powers. I accept there needs to be some process, but I don't accept that the minister has got all of the understanding when it comes to matters of planning in this state. And therefore I am concerned when we put so much power into the hands of, for a continuing and extended period of time, 18 months is the sunset period, that this may continue well beyond that period. I'll leave you to read some of these other provisions. Subsection 4, for example, it's in the same vein, and it really will probably alarm you a little bit further. I will send out all the slides at the end because the extent of the powers is just remarkable. Now, in considering and determining the development application, in answer to the question asked earlier, the Commission is to have due regard. Now, due regard means it has to think about it. It has to say, yes, we've looked at it. Due regard is more than just simply waving at a particular policy, but it doesn't mean it has to apply it or be duty bound to apply it. So it has to show that it has had regard to or considered that particular planning instrument or planning scheme, any scheme that has effect in the locality, and the need to ensure, now this very broad-based word, orderly and proper planning and the preservation of the amenity of the locality, and the need to facilitate development in response to economic effects of COVID-19 pandemic. So economic effects is right there. Never used to be a planning consideration, but it is brought in under this Act as a relevant planning consideration, and any relevant state planning policies and any other relevant planning policies of the Commission. So I want to build a nuclear power plant.
Yeah.
And I want to build that in the Bickley Valley. And the question that arises, if I want to build a nuclear power plant in the Bickley Valley and I put a proposal forward, could I
where
get
the
that up?
amenity under subsection B gives way
No.
to the economic development under subsection C? Which one has greater weight?
Well,
That's
I
the
mean,
question.
I'm going to make sure that it doesn't generate any noise. It's going to be very quiet, and it's just going to sit there and it's going to generate, no, it's going to generate power for the state. Now, okay, it might be a little bit of a way off example, but you can see that there is very broad-based powers enabling all sorts of things to be done, and provided that I at least wave at the town planning scheme and I say that it's needed for COVID-19, I say I'm not impacting on anybody's amenity, and it's orderly, and I can develop an argument to say that it's orderly and proper. In those circumstances, I may be able to get my particular proposal up and running. So, of course, I need to have regard to any of the state planning policies as well. Now, I know that I'm speaking to a lot of planners on this webinar, so I know that many of you are probably going to say, well, there's all sorts of reasons why it's not consistent with orderly and proper planning. However, you and I both know that the concepts of orderly and proper planning, which are usually influenced and informed by the planning policies, do not necessarily have to be given such weight so that they are applied, because that's not what it said. It says must have due regard to, as opposed to applied. So considered. Okay, so in addition, the Commission must consult with the EPA, consult with the Heritage Council. Now notice here, just consult, and the Commission must give any local government in whose district the proposal is the opportunity to make submissions and have due regard, again, to the submissions made by the local government within the relevant period. Section 277 applies even if the Commission's determination could not have been made by the normal decision maker. In other words, here, this is saying, look, it doesn't matter whether or not it's a decision which is an excuse, for example, or not able to be made within a particular scheme. Provided you have due regard to these relevant matters, you are able, and you have due regard to the submissions made by the local government, you're able to get your nuclear power station up and running. So time for a nuclear power station, anybody who's interested. Okay, now the Department of Planning and Lands and Heritage is where you have to lodge your application directly to. All of this is going to be included in future regulations. So the Department of Local Planning, Lands and Heritage will be the agency who will consult with the local government, and the reforms focus on early community engagement within the proposals. But as I've said to you, that engagement, that community engagement, which is intended, is going to find its way into regulations, which are going to be published into the future. And the Commission can reject proposals on the basis that they're not to be delivered in the near term, in answer to one of your points, Katrina. Now, this is a very interesting intersection. That is the intersection between the Environmental Protection Act and the Planning and Development Act. Now, I'm just going to skip a little bit further, because as you would all know, the Environmental Protection Act has this very important section. It says whenever a provision of this Act or an approved policy is inconsistent with a provision contained in or ratified or approved by any other written law, the provisions of the Environmental Protection Act or the approved policy prevails. So there's no amendment to this section, so I find it very odd. But there is amendment to what the types of policies and what sort of matters are going to be able to be the subject of review by the Environmental Protection Authority. So there's going to be a list of those amendments which do not need to be reviewed by the EPA. Now that's going to be based on a risk assessment of the proposed amendments. Perhaps these amendments make a little bit of sense, but under Section 48 AAA of the amendments to the Environmental Protection Act, which is the raft of amendment proposals, the amendment to the COVID-19 Planning and Development Amendment Bill changes both the amendments, or makes amendments to the Planning and Development Act as well as the Environmental Protection Act. So in this section, relevant scheme means of a kind referred to in section 3, and then the Governor may, on recommendation of the authority, make regulations prescribing the class of relevant schemes that are not required to be assessed under this division, and the authority must not make a recommendation unless the authority is satisfied that there will not be a significant effect on the environment. So the authority, EPA, is able to say these are schemes and these are matters that do not require assessment under the EPA, by the EPA. Additionally, there are codes, so some of these relevant planning codes, which the authority must not make a recommendation to say that, or there's going to be prescribed classes of planning codes or amendments to planning codes that do not require assessment by the EPA. So the EPA and the Department of Planning, Lands and Heritage are to determine what projects do not need to be referred to the EPA, and that's going to be finding its way into regulations. At the moment, we don't have those regulations, so we can't tell you precisely which ones are not going to be referred. And prescribed by regulations, regional and local planning schemes and amendments that do not need EPA referral. So it's going to all come down to what's included within these regulations, but the intention is, at the very least, that you don't have to have every single proposal referred to the EPA for assessment, cutting out at least the 28 days by which the proposal is then to be assessed by the EPA. And there is this risk-based assessment and the decision-making pathways, looking at complex, standard and more basic planning scheme amendments, and they are going to find their way into regulations eventually. And at the moment, we don't have them in regulations, so we can't give you a full update on what is being proposed in respect of the regulations, because remember, I said the first focus is on your Act, and then they're going to follow that up by regulations, which are being drafted at the present time, and lastly, policies. Pretty cover that. Now, there's a few important matters. Sunset on this legislation is to be 18 months from the assent of the bill. Now, throughout this webinar this afternoon, I've said I am concerned because I think once there's a taste for very broad-based powers to be given to the Minister, as well as to the Commission, it is always difficult to wrestle back away from those agencies, these powers. Does it make it clearer? Does it make it more streamlined? I don't think it meets that test, but it does try at least to provide a process by which you can get your development up and running, provided it meets with the criteria of orderly and proper planning, doesn't affect the amenity, and at least considers the state planning policies. You're able to then get your development up if it's a significant development. Now, you need to make sure that you commence your development within 48 months, so you can't leave it for longer than that. And importantly, there's also an automatic extension for all subdivision applications that did not lapse before the 16th of March 2020, which was the date on which the emergency powers came into effect through legislation. So if you have a subdivision approval in place at the present time, you've got a further 2 years. Now, I've been mentioning my concerns about the oversight role of SAT. The Commission powers are subject to the oversight of the SAT, but only by way of referral by an applicant. It is not by way of a referral by the local government. SAT is then to oversee, if there is a referral to the State Administrative Tribunal, it is to be overseen by a judicial member only, and the Minister, again, is to be given a reasonable opportunity to make submissions to the Tribunal. The DAPS, as you would have heard, is to be reduced to 3, and there's going to be regulations, which we haven't seen as yet, to specify what matters are to be determined by what is called special matter DAPS. And applications are to be assessed by the Department of Planning, Lands and Heritage. I've said that. And the local governments will have a role on these DAPS, as will the government architect. And the DAPS will consist of only 3 permanent members. They're going to be permanent DAPS. The special DAPS are to be for project areas such as, let's just say, tourism areas, and I've just thrown in an example of the Ningaloo Coast, or a particular class of application. There is also other amendments which are focused at removing or reducing red tape. to streamline the process for minor amendments to town planning region schemes, so that you don't have to go through the full process of an amendment, particularly for minor amendments. Now, Michael Huston.
Not really a question, more a suggestion. Will this webinar and your slides be available subsequently, e.g. in recorded form or some other way? And I strongly urge you.
Yep, we will make it available at the end to anybody that would wish to review it, so certainly. So there is also a risk-based assessment and decision-making planning framework for decision-making for the complex, standard and basic, as I've already said, scheme amendments to be considered by the regulations. And there's also a requirement for a 10-year review of all state planning and local government planning instruments to ensure that they remain current and contemporary. So those are good proposals to look at a risk-based assessment, look at a 10-year review process for local state planning and state planning instruments to ensure that they're all maintain their currencies. Now, this is something that's a little bit close to my heart. It relates to taking land for redevelopment. At the moment, we've got Metronet, it's a proposed beautiful railway, and a lot of iron throughout this beautiful city of ours. What it hasn't really done is included a framework, as I've said right from the outset, and has been the theme of my discussion, and that is that the blueprint framework of Metronet is not what's included within the Perth Peel 3.5 million. Now, land around train stations, most of you will know, is a beautiful black colour made up of car parking, because in this state we drive to the train stations and then we get out of our cars and we walk to the train and then we catch the train into the city because the freeways are congested. Now, the intention is to change all of those black tarmacked areas into at least areas which have and create a hub around the train station. Think Coburn City. So an area around the train station which is then developed with high density development. Now, the proposed amendment is also to ensure that there is the ability within the Planning and Development Act to enable a local government to take land for the purposes of a planning purpose, in effect. So for the purposes of the scheme. Now, there is provisions within the Act which enables it, but these amendments make it very much more clear that a public work is to be a planning scheme or a region scheme amendment of particular types. And I can imagine that there's going to be the ability to identify land around train stations to be taken for the purpose of the public work being train stations. Now, that's going to be very interesting for us lawyers, because we always, and certainly there's been some recent cases, Kimberly, on the question of what is a public work, what is the nature of the public work. It is to be assessed independently and objectively of what is contained within the taking order. So the question that is troubling my mind is, well, if there is going to be a train station which is intended to bring dividends for those landowners surrounding it, and then it is taken for the purposes of that train station, do you ignore the public work being Metronet, so that you can't take into account the uplift in value to any land holdings surrounding train stations? It's not a question on which I've answered in my own mind as yet. In other words, do you get the benefit of the train station development, or the train station that's going past, the train line that's going past and the train station adjacent, so that you can say that your land would have increased in its density and therefore had greater value as a result of the train station. Now, this is the problem with the rollout of an infrastructure proposal such as Metronet with the speed that it was done, because it really now requires some retrofitting. So the Commission may purchase any land within a proposed planning control area as well, and the land would be brought within a planning control area as a result of the change to the area, and the local planning control area, or the Commission, can then compulsorily take that land. And interestingly, the Commission is able to also sell that land. It does say if the land is no longer required for the purposes of the scheme, it can sell it. Now, that's a little bit peculiar, because it seems to then lock up that value capture that was being spoken about so regularly and so often in early days in respect of what Metronet was intending to achieve. So the policy framework, there's the intention for a policy as against or the two types of policy frameworks, the aspirational policies and those which have legislative effect, and I've mentioned that already. They're going to be divided up so that we've got a clear framework. I think it's a good idea to ensure that where those policies are really statutory in their nature, that they have the true character of being statutory in their nature. Now, the Green Paper suggested that local structure plans would have the same force and effect as a scheme. I'm not sure, unless you're going to also ensure that any local structure plan goes through the same amendment process where it can be laid before the Houses of Parliament, or at least put before the Minister for sign-off. It's an interesting question as to the framework surrounding how you would actually give a structure plan the same effect as legislative amendment or as town planning scheme. At the moment, structure plans, as you know, have to have due regard to a structure plan, whereas if they are given the same effect as a town planning scheme, they apply in the same way. There is some interesting matters in respect of the endorsement of subdivisions, plans of subdivisions, which will be you can actually receive an endorsement and then satisfy the condition later, for example, with an easement or a restrictive covenant. Okay, I think we were pretty much out of time, or nearly getting out of time. I know I zipped through that fairly quickly this afternoon, and I'm very pleased to take any questions that anybody may wish to have. In a framework and in a nutshell, I am concerned that what is being proposed is a system which does not adhere to our planning framework, which is an excellent planning framework which has been developed over a very long period of time, which provides a state planning initiative. I'm also very concerned that the suggestion within the second reading speech is that there's been a refusal of some local governments to put in clear design guidelines or design review panels to get the best design outcomes out of the proposed developments, and councils operating with outdated planning schemes that do not facilitate orderly development, as if that really is the genesis to a number of these amendments. There is, in my view, a proper recognition that the state planning framework does include state planning policies and the strategies which are proposed and required to be applied by local governments in the development of their own local planning strategies and in the development of their own local planning policies and their own town planning schemes. I'm concerned that we are moving into a system where the Minister is going to be giving increasing powers, and as I've shown you, at least through the next 18 months, the Minister being given absolute powers without regards to this particular planning framework. Okay, so if there are any questions, don't hesitate to email us. Happy to have anybody ask any questions at the present time by posting those, or alternatively putting up your hand and we can answer those as you have raised your hand. And can you just get that one? I've just got a question that's come in, so I'll just have a look. It's on the Q&A. That's
Thank
very
you.
kind. Now, somebody just raised their hand. We're just getting to that in just a moment. I'm not sure.
I found it before. I'm sure it was in here.
I think it was Antonio. We're trying to come to you just at the minute. Is it down here, Bron? Does somebody else want to raise their hand so we can just... because you disappeared after you raised your hand. But anyway, you might not have wanted to have our attention. If there is anybody who wants to ask anything or raise any matters that they would want us to discuss, happy to try to answer any questions. But can I say this, there's going to be a lot more to be seen. I do think that as planners within local governments and across Western Australia and the private sector as well, that we need to express some degree of concern. I think that everybody should equally have the COVID-19 proposed removal of red tape type arrangements applied to them equally. It shouldn't just be for the big end of town, but you can do it in a far more equitable way than simply giving all of the powers to the Minister. So can I say that there is some concerns on my part, at the very least, that we could go down the path of giving too much power to the Minister in all of these circumstances. So grateful once again for each one of your input. Sorry we can't see your hand anymore, Antonio, Can you just see if that one Q&A that's come up?
No, that's this one
That's
here.
this one. All right, but otherwise, greetings. I will send you the slides shortly, and if there is anybody who wants to ask us questions as we're moving through. We're going to organise another session on the COVID-19 amendments to this particular Act, and we're going to probably then take into account some of the further amendments. So look forward to seeing you online, and thanks for your attention this afternoon. Cheers.
Sorry, I can't find
That's all right.
your thing.
That was interesting. There's YouTube. Shared
Yeah,
on
I know, I
YouTube.
saw that, and Facebook. You can share it on YouTube. If I look at you, he's going, oh. I think you did quite well with that. So you just.
This one here.